Hello, everyone. Welcome to this new webinar. We are here with attorney Ruby Powers from Powers Law Group. And today she's going to talk about what is an I-601A waiver. Ruby, well, she is a board certified immigration and nationality attorney. She has been licensed since 2008, and she founded the firm in November of 2009. So Ruby, the word is yours.
Thank you, Maria. So the I-601A is a provisional waiver, and I really love this waiver because a lot of people came into an issue with unlawful presence after a law back a long time ago, 96, 97, called IRA, and it created unlawful presence. And so if anyone entered illegally or overstayed too much to trigger a bar after that new law 96, 97 went into effect, then this is really one of the only ways people can adjust, to obtain a legal permanent residency if they have the certain family connections and meet the requirements. So before, what happened is that people had to do all the process and then leave the country, get told at the consulate, hey, you need a waiver, and they would have to wait outside the country for that waiver. But under the Obama administration, 11 years ago already, can't believe it, they were able to, in really clean-cut cases where the only problem was unlawful presence, you could do it here in the US. Provisionally get it approved provisionally, because if you went to the consulate and they found any other issues, they would revoke this waiver, and therefore you would need to get file an I-601 for unlawful presence and what other waivers you would need, or maybe you wouldn't even be eligible if they found other inadmissibilities where waiver is not eligible for one. So this is an opportunity for those who entered unlawfully or overstayed, aren't able to adjust inside the country to still be able to find a legal permanent residency. It's very specific, so it can be complex, and this doesn't take the place of legal advice. We're giving some information. Definitely highly suggest getting a consultation. But when we're working on this, we're dealing with consular processing. And so what unlawful presence, like I was saying, was created under a law called IRA, and it actually started at April 1st, 1997. So when people come in for a consult or talk to them on the consultation, I need to know your entries and exits by the date. And it's because of that. So I need to know, because if it's less than 180 days and you left, then there's no bar, but they could add up cumulatively later on. If there's more than 180 days and you leave, there's a 3-year bar. If there's more than a year and you leave unlawful presence, then you have a 10-year bar. And generally what we're talking about, a lot of people have a 10-year bar, and we're anticipating that the I-601A provisional waiver will solve that if that is the only inadmissibility. But we also have to watch for permanent bar, and that's a big problem, because if people came and left multiple times, depending on how they entered, and unlawful presence matters, we have to calculate whether or not they'll be permanently barred. Permanently barred is a pretty big deal. If you leave the country and you're found to be permanently barred, that means you have to stay out for 10 years. Stay out for 10 years before you're allowed to submit some waivers to get back in. And so I've had a handful of cases that I've actually waited the whole 10 years. It's permanently, even though it really means a full 10 years staying out. Some people get confused because they think, oh, well, you can waive that 10-year bar. Well, when you're talking permanent bar, you can't waive that 10-year bar, that permanent bar. You have to actually stay out the whole time. So the unlawful presence calculation is really important. You might have been in a status that made you not accrue unlawful presence. So all those little details are really important. And if you want an immigration attorney who knows these things, I actually teach this to other attorneys. I teach this at law schools. I've been doing this on a very regular basis since 2008. One of my first lawyer jobs was just doing waivers before the provisional waiver existed. So one of the things that people get confused is that when they created unlawful presence and this whole waiver process, is that you actually have to have a qualifying relative that would suffer extreme hardship. And that can be lots of different ways: financially, emotionally, medically, mentally, a lot of different things. You also could have to show it's either they would have that hardship, extreme hardship, because of your absence or due to separation, or because of the relocation. It used to be both. You had to prove both, but now you just have to do one or the other. Now, one of the key points is that you need to, the qualifying relative needs to be, that would have this hardship, needs to be either a U.S. citizen or legal permanent resident, spouse or parent, not child. So you might be able to get your visa available through you having a U.S. citizen child, and they can file an I-130 for you. But if you don't have a U.S. citizen or legal permanent resident, spouse or parent, for the qualifying relative, then you won't be able to do the waiver. So anyway, this is really important, and people get confused by this. And so you need to not only have a visa available, but you also need to have a qualifying relative. Those two could be different people. It could be a child petitions for you for that first part, and your spouse, who's a legal permanent resident, is your qualifying relative. So those are things to consider. Now yes, you do have to leave. A lot of people ask, do you have to leave to do this whole process? You can do a lot of it here in the country. That's what's so great about it. And a lot of my cases are only out of the country for maybe a week, 2, depends on if there's holidays, weekends, when their appointments fall on, and dates, and also the medical exam. We've had a high success rate the whole last 11 years that this provisional waiver has been created. I think our only issue now is that the processing time is taking so long. When it came out, it was like 3 or 6 months. Now they're taking 3.5 to 4 years. So when we take on a case, we screen and we talk to our clients all throughout the process. From the beginning, we ask lots of questions because we're checking for inadmissibility issues. How did you enter? How many times did you enter? Things about military, about misrepresentation, fraud, alien smuggling, things like that. We have to ask lots of questions. It sounds like we might be intrusive, but it's because we're being a detective. Now, hardship, it can be demonstrated lots of different ways through family relationship. You have a ton of family here and you have no family in the home country. The impact of the separation from employment, family ties, professional growth, health conditions, ability to be overseen by medical treatment here in the U.S. versus somewhere else. Lots of different considerations. So the process is more or less a typical case. In fact, this is taking more than 5 years. This is maybe a 6 or 7 year at this very moment, depending on when you filed. Typical case would be like American petitions for their immigrant spouse, and the I-130 could take about a year. And then you could do the National Visa Center. You basically just pay and let them know you're going to move forward. The I-601A really takes a lot of energy because you're proving the extreme hardship to the qualifying relative, in this case, the U.S. citizen spouse. Now, right now, they're taking 4.5 years on that, and we're hoping that that'll get sped up soon. There's some lawsuits going on. Hope to see that speeding up. The national visa, right now they're saying it's about 7 months from giving everything to getting the appointment, and the visa appointment can take a little, like maybe a few weeks or so after everything is documentarily 7 months after it's documentarily bona fide with the NVC to getting that appointment. But it also depends on where you go. A lot of the cases we're running through Juarez in Mexico, but we do have cases all around the country, all over the world. And this also can depend on, so these processing times differ and a lot over time. So this is just sort of a little bit of an estimate, just to give you an idea. You go to the appointment, they review your documents. If all is well, you get the visa and your passport, you get to come to the US, pay your fee, and you get your green card in the mail soon afterwards. If there's another admissibility finding, then they'll say that it's revoked and you'll have to submit, you have to see what you're eligible for. Now, we always like to look for alternatives to waivers if there's something else better, so on. Faster, potentially. Military parole in place, 245I, U visa is taking a long time, but it can waive many things. Violence Against Women Act for men and women, parents and children and spouses. Cancellation or removal can waive lots of things, but you have to win in court, and it's extreme and unusual hardship is the standard, which is high. Asylum registries from January 1st, 1972. Adjustment status under Matriculantan, like a wave through Western Hemisphere, and maybe we have reform one day. So these are some things to consider. Also T visa as well. we like to explore other options. So this is how we went really quickly over the provisional waiver process. Wanted to let you know about that. We have lots of experience in consular processing and admissibility and waivers here at Powers Law Group. So you can reach out to us all these different ways: Facebook, X, Instagram, newsletter, TikTok. You can find us. And we speak multiple languages, and we have an English and Spanish newsletter that goes out every other week. So we also have more webinars later on this month. We do these in English and Spanish, and feel free to share, subscribe to our YouTube, send to a friend, a family. We want to be a resource for you. So thanks so much for watching, and we'll see you next time.